Hello, everyone. My name is Nicolas Merloni. I'm a professor, lawyer, and we are celebrating the World Constitution Day. And now we're going to talk a bit about brief reflections on democracy. Democracy emerged in antiquity, more specifically in ancient Greece, in Athens, around 510 BC. From Greek, we have demos as people and kratos as power. Hence, democracy means power of the people. In those times, philosophers and sages were considered citizens, able to practice political life in the public square known as agora, making decisions of interest to the Athenian city state. Women, slaves, and foreigners remained excluded from the political decision making process. Thus, there was a direct or participatory democracy restricted to a small portion of the population which deliberated on political matters. Times passed and we arrived in modernity. At this time, with the advent of the Enlightenment and the liberal revolutions, state power was delimited by laws, state of law or the rule of law, and representative democracy emerged through parliaments. Kings were no longer seen as absolute and an undeniable power. The first constitutions began to appear. So, as said, the great milestone of this era is about the limitation of state power. In other words, the practice of state absenteeism, the non interference of the state in the economy and people's lives, and also the beginning of the achievements of civil and political rights by the people, in addition to representative democracy. Later, mainly with the Industrial Revolution of the 18th and 19th centuries in continental Europe, new social demands emerged. The people demand the right to education, health, work, etc. Thus, the state starts to act in an interventionist way in society, providing the population with such social rights. It is the social state or social welfare which configures the democratic state of law and which provides the people with fundamental social rights. At this point, it's worth conceptualizing that what democracy is. Well then, it is in general terms the government of the majority respecting minorities with the protection of the values of freedom, equality, and also popular sovereignty. Now let's talk a little about our country's democracy. In Brazil, we have semi-direct democracy, that is a fusion of the previous two. We have the rulers elected by us who represent us, and we can also participate directly in the political decisions of our interest. Plebiscite, referendum, popular initiative as provided for in our Brazilian constitution. In this context, the three powers, legislative, executive, and judiciary, must live in harmony and balance without interference in the decision-making spheres of others. We have this its prediction in Article 2nd of the Constitution, according to which the legislative, executive, and judiciary are powers of the Union, independent and harmonious among themselves. The legislature creates and makes laws. The executive governs and administers, and the judiciary applies the laws to concrete cases. In these terms, one must supervise the other through the system of checks and balances. However, as we said, without undue interference in the functions and attributions of others. It's worth mentioning before moving on that the separation of powers initially appears in the first lines, with John Locke in his work Second Treatise on Government, and later developed and improved by Baron of Montesquieu in his book The Spirit of the Law. Nowadays, in our country, we have serious problem. We have serious problems in our country nowadays. Poverty, hunger, social inequalities, environmental problems, violence, religious intolerance, corruption, etc. In this scenario, our Constitution provides for various rights such as education, health, safety, a balanced environment, in economic development, job protection, etc. However, will we really be a democracy? From a formal point of view, yes. However, from a substantial perspective, perhaps not. However, due to the fact that there are laws that express rights, it is already a well-trodden path. It's now time to seek to implement such rights in social reality. Before we finish, it's important to make some relevant considerations. Magistrates, in their application of the law to the concrete case, bring social, moral, and cultural values with them in their life baggage. Thus, as much as we seek impartiality in judgments, as we said, it's not an easy task. However, judges must always pursue this principle in their decisions, and more, they must be guided by the law by obedience to the Constitution. The law says what can or cannot be done. It is about the rule of law. As we have seen, the rule of law limits state power and confers rights on citizens. Thus, trials must respect the law's due process of law with the guarantee of full defense and contradictory. And yet, very important that cannot be forgotten, power emanates from the people. The people are the legitimate holders of power under the terms of the sole paragraph of Article 1st of the Constitution of Republic, who exercise it directly or represented. So magistrates cannot go over the laws. Otherwise, they themselves would be violating the rule of law and democracy itself. That is, the democratic state of law would be confronted by the judges under the excuse of an exceptional moment to detriment of the legislative provisions that confer stability and legal security to social relations, harming the search of effective justice and an harmonious and respectful coexistence in society. Thank you very much.